Good morning.
Good morning. May it please the court, Alexandra Dale for Ms. Braune. The principal question in this case is whether the act of depositing stolen cash into one's personal bank account could constitute concealment money laundering under the Massachusetts money laundering statute. There is no question that the defendant in this case committed a crime when she received hundreds of thousands of dollars in cash stolen by her girlfriend and co-defendant, Romy Kimmel, from her parents' closet. There is also no question that after she received the cash, it began appearing periodically in her bank account at relatively regular intervals. And as the bank records show, it was the only thing going into her bank account. She was not commingling that cash with other funds. She was not transferring that cash to any other bank account. In fact, she was simply depositing the cash and then spending it on behalf of both herself and her co-defendant. As several federal courts have already made clear, the transparent division and deposit of stolen cash is not sufficient to constitute concealment money laundering.
Doesn't it matter that it's her girlfriend's money? It's not, I mean, if it's the girlfriend's money, and if the girlfriend took the money from her father-in-law and her mother and put it in her own account, I can see that's not concealing it, but you've got two factors. One, she's given it to somebody else, and two, she's breaking up the $10,000. It's always under $10,000. Aren't those two facts alone enough to meet the statutory requirements?
Let me address each one in turn. So with regard to the fact that...
And make sure you address them together, too, because I think, slicing is a little different.
Sure, and I can appreciate that, but I do think that they weren't being addressed separately because I think at least the one is kind of a red herring, and that's the question of whether giving it to Ms. Braune to deposit rather than the original thief depositing it herself is evidence of a design to conceal. And I say that because this is not a case in which Ms. Braune was unconnected to the crime. So let's just say you have a bank robber, and the bank robber goes in and she robs a bank. She comes out with a giant sack of cash, and she throws it in the back of a truck, and the truck driver drives away and deposits that cash into her account. It doesn't matter that the truck driver, rather than the bank robber, deposited the cash because these two are involved together in a crime. Similarly, Ms. Braune receives the stolen cash, deposits it in her account, and the essence of money laundering is the separation of oneself from the funds, the distancing of oneself from the funds. And in this case, there was no element of that. The money must be more concealed prior to the transaction than before. And here it's almost as if she's announcing the money.
Go ahead.
No, wasn't it more concealed? I mean,
I would argue that it wasn't.
party removed, right, from the thief.
It's one party removed from the thief, but it's not removed from
It's bad
the
money.
criminal
It's really
recipient.
bad money laundering, but it could be money laundering.
Right, and one doesn't have to be a successful money launderer to be a money launderer. I think we can agree on that. But I don't think that this is the same as the cases in which a defendant who has participated in some sort of criminal activity uses a third party, say, a daughter or a friend or whomever that wasn't involved in that criminal activity.
Well, how do we know?
To sort of siphon off the funds.
How do we know the girlfriend was involved in the original theft? We don't
She
know.
was convicted of the larceny, and there was certainly sufficient evidence at trial that.
But she might have been acquitted of that too. But that's neither here nor there, is
What
it?
about the Smurf and the under 10,000?
So, yeah, and I meant to get to that point. And I would point the court to United States versus Stevenson, which I think speaks to that in a very important way, which is that first of all, concealment implies conduct entailing deception. And deception is something more than not wanting it to be reported. So that's number one. Number two, there's a separate prong in the statute with regard to the structuring of deposits to avoid federal reporting requirements. If the legislature meant for proof of one to be sufficient, proof of another.
Not sufficient. It's just another piece of evidence, just like the retirement story is another piece of evidence going to concealment. Just like the The issue of altering some of the bank documents is another piece of evidence. I mean, it just starts right out with your first point, which is you got to take it all together, not just one of them. Sure, structuring so you're under $10,000 alone is not enough.
Right.
For concealment.
Correct. And the other pieces of evidence you just cited likewise are not enough. I mean, they're not enough in this case. I wouldn't say that generally speaking they're not enough. In this case, they're not enough because, first of all, those altered bank statements, we have no idea what those are. There was no proof other than to enter them into evidence. There was no testimony regarding who created them, how they were created, what they were used for. Had anyone ever seen them? And in fact, the prosecutor himself said in closing, I have no idea what these are. So that's not really a probative piece of evidence, I would argue. And I think with regard to the story about the inheritance, while that is in fact probative of a general deceptive intent, the fact is that this statute means, when you look at the statutory language, the deception has to be intrinsic to the transaction itself. So some motivation to conceal is not enough. One has to be using the transaction in order to conceal the money. So saying, well, I got all this money from an inheritance from my grandfather.
But it's not under the mattress. I mean, when they presumably decide to fly first class to Paris, it's not under the mattress. There's a bank account.
That's right, and there's a bank account so that they can spend it. And I think that's really the driving force here, that the motivation behind depositing this cash was to be able to use it, because I think we all know you can't walk up anymore and, give somebody thousands of dollars in wads of cash and expect not to call attention to yourself. But also, it's just a function of living in this society. Most things are done with a bank card these days. They wanted to be able to use this cash. There is no question about that. And depositing it was really the only way to be able to do that.
What perplexes me here is she was charged with violation of Chapter 266, Section 60, receipt of stolen property, but under $250.
That I'm not exactly sure what happened with regard to that, because I think the evidence was clear and the evidence at trial proved that the receipt was in excess of $250.
So the Commonwealth in this case could have convicted her of receipt of stolen property over $250 and had a maximum sentence of 5 years.
Yes, it could have.
So the issue is where they did not charge receipt of stolen property and charge money laundering, which has a maximum of 6 years, have they proven the elements that this person committed the separate crime, not merely of receipt, but of laundering the money?
I would argue that they haven't proved that. And the reason that they haven't proved it is because while they did prove concealment, which is part of the receipt statute, they didn't prove that these transactions, and what we're talking about are 9 deposits into her personal bank account in her own name. It didn't prove that those deposits were done with a design to conceal some attribute of the funds. And they didn't, in fact, conceal it, but as Justice Graziano pointed out, one doesn't have to be a good money launderer to be a money launderer.
Why would it be in the girlfriend's account as opposed, why wouldn't it be in the girlfriend's account itself instead of in this account?
Why would it be, I'm sorry?
Why would it be in this account as opposed to the girlfriend whose parents were taken, she stole her parents' money?
She did steal her parents' money, and her parents suspected that she had stolen her money.
So if she would have, if you say that the only reason to put it in the bank was to use it because you have to use it, you can't give people $10,000 for first-class tickets to Paris in cash. So you need to have the bank as a, this intermediary which provides cards and checks and so forth. Okay, so you need that. Why wouldn't she put it, but if the attempt was not to deceive, why put it in her account, the defendant's account, as opposed to the girlfriend's account who stole it?
So I think that this is what separates the money laundering from the concealment. They had a motivation to conceal the fact that the money was stolen, but that's not intrinsic to these transactions. These transactions themselves, the depositing of the money into the bank for everyone to see, is not designed to conceal an attribute of that money. Passing it along from one person to the next was motivated by that desire, for sure. But that's not
So it was a
what
desire
the
to conceal.
statute gets to.
It was a desire to conceal, you're saying? Okay,
I would, right, an overall motivation to conceal the fact of the crime. They certainly didn't want people to know that this was stolen money. But that, and the cases are quite clear on that, that is different from a transaction which is itself designed to conceal an attribute of the funds. It's not designed to conceal the crime, it's designed to conceal some attribute of those funds. And that's, I think, the missing link in this case, which is that while the Commonwealth certainly proved subterfuge and deceit, it didn't prove that with respect to the deposits themselves, and that is the essence of money laundering.
how would you do that?
How would you do that? How would you prove that a transaction is designed to conceal? Well, I think in most of the cases that you see that are money laundering, you see complicated, intricate transactions. You see somebody putting money into a business account, for example. I own a legitimate business, and I put my ill-gotten gains into the same account that I put my business money into. And so when it comes out, it all looks like my business's money. And maybe I create false invoices or whatever the case may be in order to make this money appear clean, to clean the money. This didn't clean the money. This just put the money somewhere. It made the money accessible to them to spend. So that's the missing link here. It's the idea that the laundering is something that takes the money, puts it in a place that cleans it and allows it to go into the stream of commerce or wherever in a way that makes it appear as though it doesn't have one of the attributes of the ill-gotten gains.
But that did happen when they were able to spend the ill-gotten gains, correct?
They were able to, but they would have been able to spend them. I think it's just a question of how. And in this, they were buying, you can see from the bank records, there was a lot of internet purchases, and it's difficult to do that with cash, so you do that with a bank card. And they weren't charged on laundering for the spending. She wasn't charged for the spending. She wasn't charged for those transactions. And if she were, I'm not entirely sure. But the fact is, she was charged for the deposits themselves. And that's the question, is the transparent deposit of funds into a personal bank account money laundering? And I think it's important.
So the internet transactions possibly could have been?
I haven't actually put a lot of time into thinking about that since she wasn't charged with.
But under your theory, because it's less apparent what happens, so further down the stream it could have been, right?
I don't think so, Your Honor, because I think most of the cases are fairly clear that the mere spending of criminal, gains is not money laundering. Again, those transactions have to be made with the intent to somehow conceal an attribute of the funds. And in this case, it's for personal use. It's, they're going on trips, they're seeing Diana Ross, they're buying IKEA furniture. I mean, these are things that are for their personal use.
And we know that precisely because that's what the bank statement reveals.
That's exactly right.
We
And
wouldn't know it if she actually had spent cash.
correct, and that brings me back to the purpose of the money laundering statute.
If I can, I recalled, am I correct that in the briefs that the Commonwealth in fact did argue, or at least charge or argue the alternative of the currency transaction reports, and then the judge found they were not sufficient?
Yes, so that was one of the Commonwealth's theories, was the structuring. And
Which was the subsection
subsection
B.
2AB,
And I guess what the
exactly.
judge said, there was not, you have to show that she did it with that purpose, or that that he didn't find that she knew of the
Actually,
CTR?
so with regard to structuring, he found that prior to April 27th, 2014, which was when Ms. Kimmel made off with what he just, I think, described as the mother lode of cash, when she walked out of the house with a giant bag of cash. Prior to that, the judge's theory was that, well, the Commonwealth didn't prove how much money was taken, and it may have just been that was all the money she had to deposit. So you don't have enough to prove structuring because we don't know how much money she actually, had in her possession at the time. So he cut it off at April 27th. The Commonwealth then decided, because there were only 2 dates after April 27th, the Commonwealth decided that it would proceed purely on the concealment theory, and I imagine that was just for the simplicity of the jury and not having to instruct the jury on 2 separate crimes, but perhaps also because it didn't enter any evidence that the defendant had knowledge of the reporting requirements, and that, at least under federal law, is also an element of the crime, and that wasn't something that came out at trial. Perhaps the Commonwealth recognized that and decided not to pursue the theory. I'm not clear about that. But I see that I'm running out of time, so I'd like to make one final point, which is that the reach of this statute is at least arguably ambiguous, and under those circumstances, I think the rule of lenity should compel this court to find that the open, transparent deposit of funds into one's personal account cannot constitute concealment money laundering.
All right, thank you.
Thank you.
Mr. Mallard, good morning.
Good morning, Mr. Chief Justice, members of the court. Philip Mallard on behalf of the Commonwealth.
On that last point, do you agree that if all you have is the open deposit of personal funds, and that's all you have, that's not enough for money laundering?
I disagree with that. In this case, obviously, this is a third party's account, and I'd say the bulk of the federal case law that I cited a good number of cases on this. The federal case law is pretty consistent in that third-party individuals who take the criminal activity-derived funds and place them into their own accounts or take them into their possession and transact with them is sufficient to get you into the ballpark of at least concealment on
Do we
some
have
level.
any of those cases where there's actually a significant relationship, marital relationship, a significant other relationship like we have here?
I think that there's at least one robbery case where the girlfriend deposits the money, but there's a couple of cases where it's a wife who gets it, and the court says the mere spending is insufficient. And I'm not necessarily arguing that you need to limit, that you need to find or conclude or take a position in a decision that a third party alone is sufficient. I'm not taking that position. I think the court could, in the context of an extremely unrelated third party. And this is sort of what I wanted to get to as well, is that if, for example, Ms. Braune had a legitimate inheritance and didn't structure the deposits, and as a third party took the stolen money and was proven definitively that she took $100,000 of the stolen money and deposited it into her account openly, a CTR was filed in that context, and it was proven definitively that the money was a third party transaction with the stolen funds, I think the money laundering statute captures that. Even if there is a legitimate inheritance, even if there is sort of commingling, or if there was a business, transacting the money through the business, I think would be sufficient as well with just a third-party fact, without the structure of
If
the
it's not
statute.
stolen money,
Well, no, if it's stolen, it has to be stolen money as
then
well.
it's not inheritance then.
Well, if there was a legitimate inheritance that existed
Yeah.
in account one, $500,000 of a legitimate inheritance, and then $100,000 of stolen money was deposited into that account in one large transaction, not structured, not staggered, I think that's money laundering under the statute because it's concealed and commingled in and amongst the legitimate
I
inheritance.
guess the fundamental question is, why should we be stretching to find this rather elemental transaction to be money laundering when you could have just charged her with receipt of stolen property?
She was charged with that.
But under 250?
I think that was just an oversight by the prosecutor in drafting the indictment.
An oversight? Under 250, a misdemeanor as opposed to a felony is an oversight?
From my understanding of what transpired, yes.
Really?
That
Okay.
being said,
So, I mean, so you agree that this is, you had the easy way to do it, and instead, for whatever reason, we have the hard way, which is to show that this was not only receipt of stolen property, but also that it was designed to launder the money.
correct.
Okay, so let's go over the statute. Knowing that the transaction is designed in whole or in part either to conceal or disguise the nature of the property. How did this disguise the nature of the property? It was originally cash, and now it's money that's been deposited into an account. How does that disguise the nature of the money, since it's a cash deposit?
I think if you go back to the sort of the date before Romy and the defendant take off for California, they've already sort of set the seeds for the inheritance sort of ploy. And that's told to Janice early on, and that's part of the whole basis for which they're leaving. Depositing the money in the defendant's account is part of that. They're concealing it in the account held by the defendant as opposed to the thief. and disguising it simultaneously through that deposit as this supposed inheritance, which in fact does not exist.
How do you disguise the fact that you have cash by depositing that cash into a bank account and creating a bank record that I deposited $8,000 in
They're not
cash?
disguising the fact that they have the cash. She's saying, Romy's saying, we do have the cash. It's just Shay's inheritance. So it's the nature and the control of the stolen money is being disguised as, in fact, it's the ownership is being said, well, no, it's not Romy's money. It's actually Shay. This is Shay's money. She owns it. It's her legitimate inheritance. The nature of it's being disguised by the deposit into her account, contemporaneous with the story that she's got this inheritance that she supposedly has that we're going to use to go abroad.
So the other phrase is disguise the location. No, I assume you're not arguing that.
I mean, physically speaking, I think depositing it into the bank does conceal where it physically is because it's no longer, hidden under the bed anymore, but.
It doesn't, I mean,
Isn't
instead of having cash which no one may know about, you now leave a bank record that says I deposited cash into a bank account. That's designed to conceal it.
Well-
Doesn't it conceal it more to leave it under your mattress?
In the context of what the defendant sort of put out there as the story, I'd say no. Assuming that James and Janice knew that Romy had stolen $500,000 or so, by the defendant depositing cash in the manner that she did, where that $500,000 physically is located and who has control over it and whose ownership is of that $500,000 that's stolen is concealed through the deposits and then the story that sort of the deposits support.
So it's concealed because you have your girlfriend put it in her account as opposed to leaving it in the mattress in the apartment that you both live?
In her account, consistent with the time and narrative that they're portraying that, no, this isn't stolen money, this is inherited money.
But the inherited money they claim was inherited, 8-10 years earlier.
Right.
So
Well,
how
something like
how does depositing it in the account change anything as to what the source of the money is? It's cash.
Certainly changes the ownership because no longer is it sitting in Romy's possession, it's now in Shay's possession and account for which she's a loan signatory. It changes the nature in that it's consistent with the fact that it's Shay's money and she has this inheritance that she's going to be depositing and spending at her will. And it also alters the source, obviously, because it's more consistent with that.
It's also an or requirement, right? It can be any of those four. Disguise the nature, location, source, or
I'm trying to figure out which one you're focusing on.
Well,
You're focusing on nature and source?
Nature, source, ownership, control, I think those are the operative four. And, I mean, I think location is sort of incidental, but that as well.
So anytime a husband steals money and the wife puts it into her account, which is not a joint account, it's money laundering.
No, I don't think that's consistent with the case law.
What distinguishes this case from that, except that they're not married?
First of all, if a wife were to structurally deposit money into her account that is definitely stolen or from whatever other criminal source, I think you're on the borderline of being insufficient. The federal cases are consistent with
Really,
that.
if Al Capone steals millions of dollars and puts the money in his girlfriend's account, isn't that in and of itself enough to meet the requirements of this statute?
Girlfriend's account,
Yeah.
yes. I think the financial unity of a marriage is a little bit different. And I think if she's conspicuously depositing it and conspicuously spending it,
What if what if the married couple have no joint accounts whatsoever, and then suddenly this account is created for that purpose?
I think we're getting closer, but it would have to be sort of $100,000 stolen on Monday. The wife deposits $100,000 conspicuously on Tuesday and then spends $100,000 conspicuously on Wednesday. Is that concealment? I think a colorable argument can be made on both sides of that, and I certainly am not arguing that here. Here, of course, we have a non-married couple, a large amount of money stolen over a considerable period of time. The deposits are staggered in time, for about 18 months, and they're structured in a manner to not trigger the requirements. And then also, contemporaneous with that, you have them claiming an inheritance. Not only is that claim offered to sort of conceal this money. The inheritance claim is actually false, and they then perjure themselves in the course of a couple of depositions about it, or at least provide false statements if perjury is going to be a matter of conviction, and then they lie about the nature of the transaction. So I think we're certainly well beyond sort of these close call cases that you're offering, Justice Kafker, but I think a third-party deposit with at least structuring, with at least staggering, would be sufficient. But when you get into the marital scenario, some of the federal cases kind of cut against that, but obviously we're not there.
Okay, so
Who within the statute, who is it designed to conceal the money from?
Oh, I think that's a good question, and I think it would have to be from an objective standard, from whom? Because structuring obviously would be concealing from the bank operators whose currency transaction reports would need to be filed, or in this case, the victim who rightly suspects his daughter or stepdaughter is responsible, and the use of the third party sort of takes it one step removed from the actual thief. I think law enforcement could also be a putative person from whom the concealment would be operating, but I think the court needs to look at that objectively. Or I think there's also a good potential that the Commonwealth could, I can foresee cases where, in this case, Mr. Welling is looking to find where his money went, and he is being the money is being subjectively concealed from him through some of this activity. But there's also sort of nondescript persons as well.
We do have to do something more than use the colloquial meaning of conceal. And it seems like a number of the United States Court of Appeals cases have definitions, and some are more strict than others. What's your thought as we look at some of these federal cases, since we don't have any, and the language is similar about, I think the Sixth Circuit in Falconberry has to be the concealment must be the animating purpose of the transaction. Is that a good definition?
You know, I read that case. I also read Dobbs and Blankenship, and there's a couple others that my sister cites, and I think I refer to them as well. First of all, there's certainly no requirement that the transactions have to create the appearance of legitimate wealth. That requirement was sort of read into the law by, I think Dobbs might have been the first case. That standard's curtailed by, sort of overruled by Queller in the Supreme Court case. So the appearance of legitimate wealth is no longer a necessary requirement. The animating purpose of the particular transaction. And that's where I think we get into some of the difficulties in this, not in this case, but in foreseeable cases. I think in this case we have not only the technical aspects of the transaction that reveal the concealment intent and the aim and purpose, the structuring, the staggering, and the third party. I think those three operating together certainly satisfy the design, aim, purpose of concealment. But in this case, particularly, we also have the inheritance ploy, which not only exists, but is proven false. So if there was a real inheritance, I think the staggered, structured, third party commingling would be good. But then here we have an inheritance ploy, proven false, and then other falsities that get us way beyond that. I think a combination of two is where we get into the area where a jury can find that there's an overall design, aim, purpose, intent. The animating purpose would be to conceal, and has to obviously be subject to some of the circumstances of the case, the amount of the money, the nature of the account, who owns it, who controls it, what the parties were making statements about the money source to be, how much structuring, how close to the $10,000 limit, how staggered in time, is it Monday, Tuesday, Wednesday, Thursday, Friday, or in this case, there's a couple of days in between a lot of these transactions, the amounts, what the legitimate employment is there commingling? And obviously we're speaking sort of into a vacuum here because this is the first case, but I can foresee this court structuring a rule that encourages discernment among prosecutors in terms of having strong evidence, because I think the Chief Justice is correct that, you know, what this court does in terms of the elements is important. Not every case is a money laundering case where a drug dealer happens to have drug money in his car after a drug deal. Is that going to be money laundering? I think there's a Superior Court decision on that point and says no. I think that case was ultimately a dismissal on probable cause grounds. So keeping those aspects in mind.
How about U.S. versus Johnson, 11th Circuit? There must be evidence that the funds are more concealed after the transaction than before. Do you agree that that's an appropriate standard?
Well, I think that would preclude the inept money launderers.
Sorry?
I think that would sort of preclude the application of the statute from inept money laundering schemes. The fact that it is more concealed would require sort of success in the laundering, and I don't think this court
It
should
must be designed to do that.
designed to make it more concealed.
Okay.
In fact, whether it is, I'm not sure.
Okay, do you agree that these funds, that putting it into the account meant that they were actually less concealed than they were before? Because before they were simply cash hidden away somewhere?
I'm not sure I'm not sure it's less concealed by the transaction. We're looking at this case after the fact with the whole panoply of bank records, and I can sit here and
Right, we
tabulate.
have those bank records precisely because Ms. Braune deposited the cash into the bank.
But I think this court's presuming the sort of all-seeing eye that we have now of her financial transactions. Yeah, Mr. Welling certainly didn't have access to those bank records, and certainly all he had was the deposition statements that were flatly contradicted by sort of the position of authority that the prosecution was able to bring to bear at trial. But to say that they're less concealed because we happen to have, issued all kinds of process and obtained records and presented a comprehensive and compelling case, I think sort of looks at it from the wrong end. At the time in which this $4,000 deposit on Monday is being made and spent within a couple days, I think the money is being deposited. It's into an account of a person who's claiming to have an inheritance and then spent, and the money is ultimately dissipated. So is it concealed in the course of her getting to spend it? Yes.
But your whole case was focused on, look how much she deposited into the account. She has no legitimate source of money. That money had to come from the cash that was stolen from her house. That was your case.
Correct, and that's
You
important for
relied
all the-
upon the fact that you could demonstrate how much money had been deposited and spent precisely because you had the bank statement.
Correct, but what's this court's evaluation period going to be? In that individual date, is that $4,000 more concealed than it is sitting with the rest of the $600,000 that was stolen, $500,000 that was stolen? Potentially, yes, because they have access to it. They can spend it in a way that they want on things that they might not otherwise be able to.
Right,
And
so
then
I mean,
dissipate.
but doesn't that go that the design was to be able to use a debit card as opposed to conceal?
Well, I think the fact that they intended to spend is important, but they intended to spend it and not get caught, which is why she's depositing it in amounts that are, $4,000, $5,000, $6,000, $7,000. And that's concealed the fact not only that they have the stolen money, but that it's stolen money that they're using, and that they're trying to conceal it under the auspices of this inheritance.
Doesn't Justice Cypher's question about concealed from whom, the money wasn't concealed from the rightful owner before. They're concealing it from the rightful owner, right? Does that matter?
That, I think that does matter from the rightful owner, from tax authorities. There's like literally $250,000 in income that Ms. Braune puts into her account while then taking a deposition where she under oath claims that she hasn't really been employed and made no money.
I don't know if your best bet is the tax authorities, because I don't know what the $600,000 was doing in a box before then.
Right.
Right, I would think IRS would be thrilled if people were to take all their cash and to deposit it in a
Right.
U.S. bank.
But in the manner that they did, potentially not. It wouldn't trigger the CTR in the same way. $600,000 in one transaction, I could see that being the case, but obviously not when you're doing it step by step over time and in small amounts. It doesn't have the same, obviously, there's an
In
entire
other words,
prong
if you
for
come
that.
in with the trash bag and you deposit $600,000 all at once, that's not as good a job at concealment as doing it in $3,000 or $4,000 or $5,000 increments.
Right, and I think of this too. If I were to rob a bank tomorrow and give my wife $500,000 and she took it down to the bank and deposited it that day of my bank robbery and spent it on all kinds of wonderful things for us, am I really concealing it? No, I'm driving the car that I've always wanted, and I'm not sure concealment exists in that context. A, she's my wife, so it's not necessarily a third party in the same way, but even if she was my girlfriend and the car comes back and it's at my house, concealment does, it's an argument on both sides, and I could certainly see this court or another court finding that to be insufficient. That's not the case here, obviously. If there's no other questions, I'm happy to rest on the brief.
All right, thank you.
Thank you.